Direct Connection is made by MPT to serve all of our diverse communities and is made possible by the generous support of our members. Thank you. Live from Maryland Public Television, this is Direct Connection with Jeff Salkin.
Hi, everybody. Thanks for tuning in for Direct Connection. The FBI investigation of Supreme Court nominee Brett Kavanaugh has reportedly been expanded in scope, but not duration. The results are still due, and the Senate is still planning a final vote at the end of this week. Tonight, answers to your questions about the future of the court and the impact of these sexual assault allegations. Joining us are Lee Goodmark, professor and founder of the Gender Violence Clinic at the University of Maryland School of Law, and attorney and Supreme Court expert Arthur Ferguson. Thanks to both of you for being with us.
Thank you for having me.
You're legal experts, and this is really a political matter at this point, but where would you put the odds of a Kavanaugh confirmation as we sit here Monday night, Lee?
I would say I'm still at 50-50. I think it depends to a certain extent upon what the investigation turns up. I think that people are every bit as polarized as they were several days ago as to whether you believe Dr. Ford or you believe Judge Kavanaugh. And really having three senators who are really at play here, for me, it's still 50-50. I'm not sure what Collins, Murkowski, or Flake is going to do.
Arthur, 50-50?
No, I think we have a preponderance of the likelihood, even though Rachel Matthews, the investigator, said, I'm coming off her report that came out in the Washington Post today to the Republican senator. She was the questioner who said that she did not believe that the allegations rose in evidence to even a preponderance of the evidence.
So you think he has a better than 50-50 shot?
Yes, I do. Because if you start with the four witnesses whom she has finally now identified as those present, they've already made statements. They've made statements under oath to the committee. If they change those statements in any material way, they could be subject to prosecution. And that,
so you don't think they're going to tell the FBI anything different than they've already said?
Right. And if I were their lawyer, I would say to them, I want you to tell the truth. You have to walk a very narrow line. But if you change your
same
story,
truth.
Yes.
Right.
If you deviate, and of course you should tell the truth, but if you deviate, then you could be prosecuted, in which case they won't. And at least one report I read today said they haven't.
Lee, what do you make of that report? I haven't seen it. In fact, didn't know she was, I thought she was in the role of the hired gun questioner. Didn't know there was a report coming.
So the report is entirely consistent with the questioning that she did during the hearing, in that it was interesting. There was commentary on social media saying, oh, she's not cross-examining as thoroughly as she could or as harshly as she could. It was pretty clear to me that what she was trying to do was to set up exactly what she's written in the report, which is to pick out what she calls discrepancies, which I would disagree with in some cases, in Dr. Ford's story and in between the stories of Dr. Ford and some of the witnesses. So some of the discrepancies that she picks out, for example, are things like she was in her late teens versus she was 15, sorts of things that to me don't feel like the kinds of discrepancies that should take down a story, but will be made much of.
And is this typical he said, she said? And in your experience, I mean, focusing on these sorts of cases, is that where you typically are in a case?
So the vast majority of these cases are necessarily about credibility, though he said, she said is a term that makes some of us who do this work bristle.
Why?
But they are about credibility because it implies that the stories are of equal weight, that people have equal motivations to lie, and it's a bit dismissive, actually, as a term when talking about issues like gender violence, which are fairly serious issues. But in terms of credibility, which really is at issue, what's interesting to me is this idea that her testimony alone is not sufficient to establish credibility. In fact, it is. And even under a preponderance of the evidence standard, if you believe her testimony, that is sufficient to believe that that kind of violence has occurred. If we were in a Maryland court and she was seeking a protective order against Judge Kavanaugh and trying to meet a preponderance of the evidence standard, if her testimony were deemed sufficiently credible, that would be enough.
That's something I wanted to ask you. If you had an event like this take place in 2018 in the state of Maryland, legally, what would come of it?
So it would depend upon whether someone sought criminal or civil charges, of course. In the civil system, which is the system I was just discussing, one could seek a protective order, a domestic violence or sexual violence protective order. One would have to prove by a preponderance of the evidence that some form of abuse had occurred, and what Dr. Ford alleges falls squarely within that protective order statute. So if that testimony would be sufficient, right, if it's believed. In the criminal realm, of course, we're always in the world of beyond a reasonable doubt, and it's much more complicated in terms of kind of the gradations of assault and the types of sexual assault that one might pursue. And it could be anything from a misdemeanor, second-degree assault to a much more serious sexual assault.
Is it possible that Dr. Ford could bring a civil action at this date, although it's certainly been tried in the court of public opinion? But I understand the prospect of a criminal action is negated by what the law was in the 1980s.
Well, so the criminal action is remote but not impossible. Because Maryland recognizes the common law felonies, and there's an argument to be made that the statute of limitations doesn't necessarily attach to the common law felonies. It's a bit more attenuated. And I think
difficult?
Difficult, and it's a much more complex legal argument than saying simply there's a statute, he falls within it. But in terms of a civil case, the judges really, although there's no requirement in the statute that something have happened within a particular amount of time in the protective order statute, and then we get into all kinds of other vagaries, but the judges are really looking for things that have happened fairly recently. It would be ridiculous, quite frankly, for her to seek civil protection at this point using that kind of statute.
Let me remind our viewers, if you would like to join our conversation, you can give us a call. The number is up on the screen. You can also ask a question by email. The email address is livequestions@mpt.org. Arthur, you wanted to jump in?
There's a difference between testimony being sufficient to support a verdict in a civil case, civil liability. And I've been a federal prosecutor and I've litigated civil matters, and saying that in this case, looking at the evidence as marshaled, that it achieves that level. If you were looking at this evidence, would you determine, and the inconsistencies, some of which are quite substantial and recent, would you conclude that this woman has met the test of sufficient support for her allegations? Does it move the allegations into something warranting belief? And I think I would invite your readers, who are all very smart, or
of course,
the people watching, not readers, all very smart, to read the marshaling with an open mind. And I think they will see that these are not minor inconsistencies.
Let's take a phone call. Calvert County, this is Larry. Larry, thanks for the call. Go ahead.
Yeah, I just want to make a statement. It stated that two individuals that stated that they were there, not Judge Kavanaugh. And, this is 36 years ago. And now the Senate Democrats are stating now they want to question like 24 people. And Chairman Grassley has set the deadline Friday, so that's 5 days. So I just think it's just that's like a prolonged process. They want to prolong it. They don't want him to be confirmed. And I just
Larry, thank you very much for the phone call. If Judge Kavanaugh is seated on the Supreme Court, how does that affect the balance of the court?
Well, he's a conservative. I think that if we look at him compared to the man whom he would replace and for whom he clerked,
Kennedy.
Justice Kennedy, Anthony Kennedy, I think he would follow right down the line on Justice Kennedy's views in the First Amendment. And he was stalwart, as far as my side is concerned, on the First Amendment. On the mysteries of life jurisprudence of Justice Kennedy, I don't think he would take it any further. That begs the question about whether he would vote to reverse Roe v. Wade, and I don't think so. He gave a very careful analysis of stare decisis. which is you let the opinion, you let the wisdom stand. And there are certain changes. When I clerked for Warren Burger, Justice White was very careful about stare decisis. And under those circumstances, where he felt it was justified to change the law.
Was Kennedy was the fifth vote to maintain Roe, or was it?
Yes.
Okay.
Lee,
you see something different happening?
Only in that keeping Roe or not keeping Roe is really not the issue anymore. So there have been so many targeted restrictions on abortion providers, these trap laws. And what the trap laws have done is really eat away at the protections that are provided by Roe. So whether Roe continues to exist or not, I think it's pretty certain that Justice Kavanaugh would support these continued restrictions on abortion that make it much more difficult to obtain. Roe exists in name, but not so much in function.
Because it's been nibbled away at with restrictions.
And I think Judge Kavanaugh would continue to do that.
It's important to note that Maryland has a law. It was voted on, referendum, and I voted for it.
It was a landslide. You weren't alone.
I wasn't alone.
Right.
But I believe that's the right way to do it. Marriage equity, same-sex marriage, was also voted in Maryland, and I voted for it. And that is the process that I want to preserve. And so Maryland will continue to have the rights set forth in the law and will not be affected by any change in Roe.
It's a whole other conversation that we could have sometime, because the 73 it was Roe, right? The world of reproductive medicine has completely changed. There were no drugstore pregnancy tests. There was no Plan B.
And I think the one thing that does give reproductive rights advocates some pause is Justice Kavanaugh's description of emergency contraception during the hearings as a form of abortion. That's not correct, and it really does give people pause.
Where is Roberts on this? He would be a vote to overturn Roe?
I think so, but I agree with you that it would not be done in one fell swoop, even if they wanted to. You have to look back at what was called the genius of the approach that Justice Marshall took for moving from Plessy to Brown. And moving from Plessy to Brown was in baby steps. And what it did was it preserved the image of the court as not flipping when you flip a justice. That is, if you have a major decision you want to change. I don't think anyone disagrees.
So they don't want, as an institution, they don't want earthquakes.
No. If you wanted to do it, that's the way to do it.
Let's take another call. Anne Arundel County, this is George. George, thank you for calling. Go ahead.
Thank you.
Sure. Your question, sir.
I want to know what your guests think about the questioning, not the answers, but the questioning during the hearing, which I just thought, particularly given the publicity and the high profile, it was completely pathetic and vapid. They didn't ask any serious questions.
George,
asked her about, how she got there and how she got home and why she didn't, after being assaulted, why she wouldn't have said something to other females there on her way out the door. And for him, how much he normally drank and how much the most that he would drink.
George, we got it. Thank you very much for the phone call, sir, because I want to bring in an email question, sort of the flip side of that. Is Kavanaugh's demeanor during the hearing what we should expect from a Supreme Court justice? So both sides of it. The senators, the potential justice.
So there's been a lot of criticism about Rachel Mitchell's questioning. I thought it was fairly predictable. Her goal was to find the inconsistencies that she saw in Dr. Ford's story. We can disagree as to whether we think those are inconsistencies or not. Yes, much of the questioning from the senators was grandstanding. That's not unusual in that context. And whether anyone thought that was going to be a true truth-finding kind of place, a place where we actually knew what actually happened between these two people, they would have been sorely disappointed and also, I think, a little deluded.
A little naive,
that was never going to happen,
right,
in that setting. I think that was clear from the way that Senator Grassley started the hearing, which made it pretty clear to me that he had prejudged and that he was very certain that Dr. Ford could not persuade him differently. As to Judge Kavanaugh's demeanor, I would be loath to appear in front of any judge with a demeanor like that, and I have appeared in front of judges with demeanors like that. He did not show himself to be of the kind of judicial temperament that I would want on the Supreme Court. When challenged, he was sarcastic, he was aggressive, he was unnecessarily rude to Senator Klobuchar in ways that I think showed what happens to him when his privilege, when his power are challenged in any way. And yes, if you believe that she is not telling the truth, if you believe that Dr. Ford is lying and that Judge Kavanaugh is being unjustly accused, then one might argue that that anger is warranted. I would argue that under any circumstance, that is not the way I would want a judge to act under pressure.
Arthur, no justice would want to have that sort of video on the record in terms of judicial temperament.
Well, how he acts on the bench, and every indication is that he acts appropriately on the bench and in chambers with people. He's not like Alex Kozinski of the Ninth Circuit. No allegation has been given by any of his clerks or any of his judicial staff or any of the other judges in the D.C. Circuit. Even Chris Coons, the Democratic senator from Delaware who appeared with Jeff Flake, said that he was right to be angry. The only line he drew was what he considered to be the partisan attack, that this was revenge for Hillary's defeat. And Jeff Flake agreed with him. Now, I think
he said he had no editor. Any editor would have stricken the word Clinton.
Yes, right. and that he apologized to Senator Klobuchar, if that's how you pronounce her name. But
for the "have you blacked out" question, for that one?
Yes.
Yes.
Yes, right. He apologized. If he had come in and very methodically and dispassionately responded to the allegations against him, he would have fallen into the Dukakis trap in the debate. What would you do, Governor Dukakis, if your wife were raped and murdered? Would you still support the death penalty? And he gave a very dispassionate, lawyer-like response.
Good memory. That was a long time ago.
That was a long time ago.
Let's grab another phone call. Anne Arundel County, let's talk to Kate. Kate, thank you for calling. Go ahead.
Okay. Well, I totally agree that his demeanor was outrageous, and he doesn't belong in the Supreme Court. And I think that the comparison to Dukakis is ridiculous. So I'm sorry, but I just think the guy's unhinged.
Kate, thank you very much. I think she missed your point with Dukakis.
But I don't disagree with her, and here's why. Dukakis was running for president. And we expect our politicians to have a certain amount of fire, a certain amount of passion in what they do. We don't expect that from our jurists, and we especially don't expect it from our Supreme Court. The way that he handled the questions suggested a contempt for the senators who were questioning him that I think is really problematic in someone who's called to make decisions about the appropriate balance of powers in our country.
Let's see. I have to read this one because it begins with the words, "Could your impressive experts advise on this question? Would sexually aggressive, alcohol-fueled conduct as a teenager decades ago, reprehensible as it retrospectively is, disqualify an otherwise morally and intellectually capable candidate today?" In other words, is there a statute of limitations on this?
Not if that person had taken responsibility for that behavior, had been held accountable for that behavior in some way, and could talk about the things that they had done to change. So I can imagine a world in which Judge Kavanaugh came to the table and said, I drank a lot as a teenager, and at times I was blackout drunk, and I don't always know what I did then.
George W. Bush, when I was young and irresponsible, I was young and irresponsible.
Right. And if I did what Dr. Ford, I don't have any recollection of doing what Dr. Ford describes, but if I did that, I am deeply, deeply sorry. And here, let me show you what I've done for the last 30 years to make amends for that behavior. I've coached basketball teams, I've hired women clerks, I've done all of these other things because I recognize that that behavior at that time was problematic. If he had done that, we would be having an entirely different conversation. I don't think that anyone's acts as a teenager should disqualify them from anything if they are reflective about those acts. They take accountability for those acts, and they tell us what they've done to change over time.
That's a great point. You agree he could have calibrated the response differently?
No. But I do think that if he did this, I'm with Bret Stephens. The New York Times has two anti-Trump conservatives who are op-ed. One is Ross Douthat, who's spent most of his time.
You're an anti-Trump conservative, aren't you?
Yes, I am.
You're complaining about the anti-Trump.
No, I am. No, I mean I'm glad they have some conservatives, and sometimes they put on the head of AEI. But Ross Douthat has spent most of his time recently on the Catholic Church, following up on his book. But Bret Stephens had one column in which he said that if this man, if Judge Kavanaugh had done this, it disqualifies him. I agree. In his most recent column on this Saturday, he said that to vote on the basis of things unseen and unproved is a road to national ruin. And he said, I believe versus I believe leads us to unproven allegations that goes down the road to birtherism, which is our current president's bizarre
in
fixation.
this cauldron of everything, I mean, the gender assault, Supreme Court politics, you have a ticking clock. There's an election coming up. The Senate may flip. The president, if he wants a conservative replacement, and if the Senate Republicans want that, they have strong incentive to find a way to confirm Kavanaugh, because it takes a couple of months at a minimum to get somebody cleared, doesn't it?
Yes. I think that the practical, so the left was already excited and eager to, in conjunction with the resistance, to vote in this election. I think what Kavanaugh did, for good or ill, was to energize the right.
Does it have to fail? Does he have to withdraw or be voted down to truly energize the right?
No, he has to win to energize the right.
How so?
I think there would be a dispirited reaction because the Republicans, for good or ill, control, by a very narrow margin, by 51 votes, the Senate. They can only lose one. If the Republicans can't do this, then there will be I agree that.
But the conventional thinking is if Kavanaugh is confirmed, it's women who are going to be further energized.
Some women. I mean, you can't get away from the fact that 53% of white women voted for Trump, and many of those women are doubling down on Trump. The most horrible thing that I saw in all of this mess was a woman with her two daughters saying, even if he did it, I think that's okay. There are a lot of people out there, there are a lot of women out there who are not going to turn on Trump no matter what he does. And so when we talk about women, we need to be really thoughtful about who we're talking about.
Let's get another phone call. Montgomery County, this is Matthew. Matthew, thanks for calling. Go ahead.
Yes, my question goes to the whole issue of the lady, Dr. Ford's motive. If initially she insisted on confidentiality and anonymity, what did she expect Senator Feinstein and the Congress lady to do with the information which she passed to them?
Interesting question. Thank you very much, sir. If you do want confidentiality, the United States Senate is probably not the place to turn.
But I want to commend
she may not have known that.
I really want to commend Senator Feinstein. I know that much has been made about the short timeline and about that being a ploy of the Democrats. I just don't believe that. Senator Feinstein did what we would ask anyone to do when dealing with a victim of gender violence, which is to listen to them. Dr. Ford was not ready to come forward. Senator Feinstein held the allegations until such time that Dr. Ford was ready to come forward. That is what we ask people to do. Yes, it makes all of this much more complicated. Yes, it opens it up to conspiracy theorists. But at that point at which Dr. Ford was ready to do what she called her civic duty, and I dare say that very few of us, if they saw that to be their civic duty, would take that road. When she was ready, that was when Senator Feinstein made those allegations public.
It's a hard road. And other women are taking a certainly less publicized trip down that road. calling into various hotlines
crashing the
over things that
hotlines.
happened either recently or in the past.
And just most tellingly, I think, with Senator Flake, the video of the two women who confronted Senator Flake in the elevator and said, "This is what happened to me and this is why I didn't tell," I think had some impact on Senator Flake in asking for the investigation.
Arthur, half a minute.
Okay, chronology, look at Rachel Matthews' chronology. This was, and she said that it could well have influenced the testimony. As to motives, I don't know. We take the allegations. I would disagree with everyone saying, well, she could have, including Judge Kavanaugh. I don't dispute that she was a victim of sexual violence. I don't want to look at her motives. Some others do. I think he did that, and the Republicans did that to show they were compassionate.
In the time I have left, let me ask Lee to tell us about your book. His provocative title, Decriminalizing Domestic Violence, in a sentence.
So in a sentence, the United States has devoted most of its law and policy on domestic violence to the criminal legal system and to criminalizing domestic violence. I think that's been largely unsuccessful. The book explores why that's true and what we might do differently.
Lee Goodmark and Arthur Ferguson, thank you both for the time. We appreciate it. Thank you for watching Direct Connection. We are back Thursday with Your Money in Business. Have a good night.
This program was made by MPT to serve all of our diverse communities.